tell you what's in store when it comes to the Supreme Court, which is scheduled to hear a batch of PILs challenging the validity of the certain provisions of the 1991 law that prohibits filing a lawsuit to reclaim a place of worship or seek a change in its character from what prevailed on the 15th of August 1947. A three-judge bench of Chief Justice Sanjeev Khanna, Justices Sanjay Kumar and K.V. Vishwanathan will be hearing the matter. The act, which preserves the character and the identity of religious sites as they stood on the 15th of August 1947. However, many petitions challenging the Places of Worship Act are pending in the top court. Petitioners have been claiming that the act bars the remedy of judicial review and also violates the principle of secularism. With on the other side, the IUML, which has filed an intervention application before the court in the pleas challenging the validity of the Places of Worship Act, which the application states that the 1991 Act seeks to protect secularism and religious freedom of all faiths in the country. The application also mentions that secularism has been held to be a part of basic structure of the Constitution, and even Parliament is prohibited from amending the Act. Let's in the meantime also talk about when it comes to the Places of Worship Act in the Supreme Court and what exactly are the key arguments that have been put forth by the petitioners in the case. Let's put that out for our viewers to see exactly when it comes to the Places of Worship Act and multiple pleas that are now pending in the Supreme Court, as the Supreme Court will be taking up the case of those petitioners there. Now let's tell you exactly when it comes to the arguments that have been kept forth. Argument 1 suggests that the Act actually takes away the rights of the Hindus. It takes away the rights of Jains, Buddhists and Sikhs as well. Another argument, let's talk that about when it comes to the Act. They say that it takes away the rights to reclaim places of worship and saying that this is something that the Parliament can also not restrain devotees when it comes to getting back their religious places of worship. It is a matter of faith. Another argument that is now posted saying that the Act, the Places of Worship Act, bars the remedy of a judicial review completely. Let's quickly turn in a word from Harish, who is joining us this morning. Harish, good morning. Big day we are looking at in the Supreme Court. Of course, we are looking at several pleas and petitions that have been taken up challenging the very validity of the Places of Worship Act.
Yes, good morning, Amita. Yes, the hearing will happen at 3:30. The bench led by the three-judge bench led by the Chief Justice Sanjeev Khanna. Around 10 petitions have been listed which have challenged the constitutional validity of the Places of Worship Act 1991. Prominent among the petitioners are Ashwini Upadhyay, Subramaniam Swamy, then Advocate Vishnu Shankar Jain, who has been leading the charge for the Hindu side as far as the Ayodhya judgment, Ayodhya case. Also Gyanvapi, Sambal and also Mathura Krishna Janmabhoomi cases. And as rightly said, they have argued that the Act takes away rights of Hindus, Jains, Buddhists and Sikhs to reclaim their places of worship through courts and legalized illegal acts of invaders. They also argue that Parliament cannot restrain Hindus, Jains, Buddhists, Sikhs, devotees from getting back their religious place of worship. And also the Supreme Court may have in its Ayodhya judgment upheld the validity of the Act, calling it a legislative instrument. But they say that these remarks were mere observations without any judicial force, as the Act was not under challenge during the proceedings. At the same time, several Muslim sides have filed intervention petitions like Jamiat Ulema Hind, the Gyanvapi Mosque Committee, All India Muslim Personal Law Board. They have argued, they have even urged Supreme Court not to entertain this petition, saying it will create fear in the minds of Muslim communities still recovering from the communal divide caused by the Babri demolition and Ayodhya judgment. Right. And they also allege that it will open floodgates of litigation against countless mosques in the country. And what is important is, Amita, the center is yet to file its response affidavit 3 years and 9 months after the first notice was issued to it. So that all will be taken into consideration by the Chief Justice bench today.
All right, please to stay on with us, Harish, because as far as what is this intervention plea all about, that has now been taken up by the IUML as far as the Places of Worship Act and its validity that is now being challenged as part of the several petitions that have been taken up with the Supreme Court will be hearing today. Let's tell you exactly when it comes to this intervention plea and what it upholds, saying that the Places of Worship Act could have prevented the Sambhal violence. And even when it comes to the act itself, which actually seeks to protect secularism and religious freedom, saying that this is the very source of secularism that needs to be held as a part of basic structure of the constitution and hence cannot be challenged even when it comes to the parliament of the country, which is prohibited from amending the very act. This is as far as the intervention plea that has now been taken up on part of the IUML as well, suggesting that even when it comes to the recent incidents that have taken place, especially when it comes to UP's Sambhal, however, they have been saying that this entire incident could have been avoided. Of course, we have seen when it comes to the intervention plea, which also goes on to talk about that the Places of Worship Act could have prevented a Sambhal-like incident. All right, we will be keeping our eyes out on today's development as far as the take-up in the Supreme Court of India. Let's in the meantime